What happens when a man who has spent his entire life buying his way out of consequences finally walks into a room where money means nothing? It happened on a Tuesday morning in downtown Atlanta, Georgia, inside a courtroom that smelled like old wood and fresh coffee. The kind of room where truth has a way of surfacing whether you want it to or not. Most people would have been nervous walking in there. Most people would have at least tried to look humble. But Caldwell Pierce was not most people, and he made sure everyone in that building knew it before he even reached his seat. The case itself wasn't complicated, at least not on paper. Pierce Industries, the real estate and development empire that Caldwell had inherited from his father and expanded into a multi-billion-dollar operation, was being sued by a class of former tenants. Dozens of families who had lived in Pierce-owned properties across the Atlanta metro area. Families who had paid rent on time, followed every rule, and still found themselves displaced when Pierce's company decided the land was worth more developed than occupied. The lawsuit alleged wrongful eviction, breach of contract, and deliberate housing code violations that the company had allowed to fester for years, knowing full well that the people living in those units couldn't afford to fight back. But they were fighting back now, and that fight had landed everyone in courtroom 14B. Judge Elaine Mosley had been on that bench for 11 years. She had presided over everything from white-collar fraud cases to wrongful death suits involving some of the most powerful names in Georgia. She was 53 years old, sharp as a blade, and not the kind of person who needed anyone to tell her she had earned her seat. Her record was clean. Her reputation was unimpeachable. She was known for running a tight courtroom, no grandstanding, no theatrics, and absolutely no tolerance for anyone who walked in thinking the rules applied to everyone except them. Attorneys who had appeared before her knew to come prepared. They knew to come on time, and they knew, above all else, to stand when she entered the room, because that was the law, not a suggestion, not a courtesy, but a legal requirement that every person inside those four walls was bound to honor. Caldwell Pierce had been briefed on all of this. His legal team, a row of suits from one of Atlanta's most expensive firms, had walked him through courtroom protocol the night before. They told him what to expect. They told him how to behave. They told him specifically that when the judge entered, he needed to stand. Caldwell had nodded along like he was listening. But the thing about men like Caldwell Pierce is that they hear what they want to hear and discard the rest. The morning of the hearing, he arrived in a black Mercedes with tinted windows, flanked by two assistants who carried his briefcase and his coffee. He walked through the courthouse lobby without making eye contact with a single person. He didn't speak to the security guards at the scanner. He barely acknowledged his own legal team when he reached them in the hallway. He straightened his cufflinks, checked his watch, and walked into courtroom 14B like he was walking into a board meeting he could leave at any time. The gallery was already filling up. On one side sat the plaintiffs, 37 families represented by their lead attorney, a woman named Grace Tillman, who had spent the last 2 years building this case from the ground up. Behind them were journalists, community organizers, and a few housing advocacy groups who had been following the lawsuit since its filing. On the other side sat Pierce's legal team, polished and prepared, and now Caldwell himself, dropping into his chair with the relaxed energy of a man who didn't believe anything in this room could touch him. The bailiff's voice cut through the murmur of the gallery. "All rise." The words landed flat and firm in the air. Every person in that courtroom got to their feet. Every person except one. Caldwell Pierce stayed seated. He didn't shift in his chair. He didn't glance around. He simply remained where he was, one arm draped over the back of his seat, legs crossed at the ankle, as Judge Elaine Mosley walked through the side door and stepped up to the bench. The room noticed. You could feel it, that collective intake of breath, that ripple of discomfort that moves through a space when someone does something they absolutely should not do. Grace Tillman, standing at the plaintiff's table, caught the moment and kept her face steady. A few jurors in the box exchanged glances. A journalist near the back of the gallery tilted their head and started typing. Judge Mosley herself paused at the top of the step, just for a second. Then she sat down. She looked out over the courtroom, her eyes moving methodically from left to right until they settled on Caldwell Pierce. She held that gaze for just long enough to make everyone in the room uncomfortable. Then she spoke. "Mr. Pierce," she said, her voice level and unhurried. "I don't believe we've been formally introduced. I'm Judge Elaine Mosley, and in my courtroom, when the bailiff calls all rise, that instruction is not optional." Caldwell looked up from a phone he had been scrolling through under the table. He offered a smile, the kind that came easy to men who were used to charming their way through difficult rooms. "I apologize, Your Honor. Force of habit. I spend most of my time in meetings where standing isn't really a thing." A ripple moved through the gallery. Someone coughed to cover a laugh. Someone else didn't bother. Judge Mosley did not smile back. She picked up her pen, made a note, and said quietly, "We'll consider that your first warning, Mr. Pierce. I won't be issuing a second. Let's begin." And just like that, the hearing was underway. But what Caldwell didn't understand, what he couldn't have understood from inside the comfortable bubble he had spent his whole life constructing, was that the moment he chose to stay seated, the real case had already begun. Caldwell Pierce had not started rich. That was the detail most people didn't know, the one that got buried under the weight of the Forbes profiles and the magazine covers and the charity galas where he showed up just long enough to be photographed. His father, Robert Pierce, had built the first Pierce property management company from a single rental duplex in Savannah. Robert was a disciplined man, methodical, careful. He believed in handshakes and honesty and treating tenants like neighbors because that was just how you ran a decent business. He had passed those values down to Caldwell along with everything else. The problem was that Caldwell had taken the everything else and left the values behind. By the time Robert passed and Caldwell took the reins, Pierce Industries was a mid-sized regional firm with a solid reputation. Within 8 years under Caldwell's leadership, it was a billion-dollar machine. He had acquired properties in 7 states, developed luxury condominiums on land that used to hold affordable housing, and restructured the company's rental division in ways that maximized profit and minimized accountability. He had a gift for reading markets and an iron willingness to do whatever the numbers told him to do, regardless of who got displaced in the process. The tenants who filed the lawsuit against him weren't abstract. They were people. Marcus and Denise Hawley, a retired couple who had lived in the same Pierce-owned home for 16 years before receiving an eviction notice with 30 days attached to it. Tanya Reeves, a single mother of 3 whose apartment had a mold problem she had been reporting to Pierce Industries for over a year, documented in writing, unanswered in practice. There were 35 more stories just like theirs. Grace Tillman had them all organized, time-stamped, and ready. Grace Tillman had not taken this case for the money. The contingency fee structure barely covered her overhead. She had taken it because she had grown up in a Pierce-owned building. She knew what it felt like to live somewhere that was managed like an inconvenience rather than a home. She was quiet about that in public. In private, it had been the fuel in her engine for every late night, and every weekend she had spent building this case into something a courtroom could hold. She was 38 years old and had been practicing law for 12 years. She wore her hair natural, kept her suit simple, and had a habit of pausing just a beat longer than people expected before she spoke, which tended to make people lean in without realizing it. She was not flashy. She did not need to be. The facts she had assembled were flashy enough. Caldwell's lead attorney was a man named Bradford Holt, senior partner at Holt, Meridian & Associates, the firm that Pierce Industries had retained for more than a decade. Holt was good, very good. He had the kind of courtroom presence that came from 30 years of expensive wins. He was tall, silver-haired, and moved through legal arguments with a smooth economy that juries found reassuring. He and Caldwell had worked together long enough that they communicated in shorthand. Holt knew how to manage his client's ego, or at least he thought he did. The first 2 days of the hearing moved the way complex civil litigation usually does, methodically, carefully, with long stretches of document review and procedural back and forth that tested the patience of everyone in the gallery. Judge Mosley ran it all with precision. She asked sharp questions. She sustained objections that deserved sustaining and overruled the ones that didn't. She didn't favor either side, and she didn't pretend to. Caldwell sat at the defense table and looked increasingly bored. On the second afternoon, Holt leaned over and whispered something to him. Caldwell gave a small shrug and straightened in his chair, but the shrug was visible and the gallery noticed, and that detail made it into at least 2 different news reports published that evening. On the third morning, Grace Tillman called her first major witness. Marcus Holley, 71 years old, walked to the stand with a cane and the careful dignity of a man who had earned every single one of those years. He described the eviction notice. He described the calls to the Pierce Industries tenant line that rang and rang and rang. He described the morning he and his wife had to carry their belongings out to their daughter's car because there was nowhere else to go. His voice did not shake. It was the steadiness of it that made people in the gallery go quiet in a way that was different from before. It was the quiet of people recognizing a truth they already knew somewhere in their chest. Grace asked one final question. Mr. Holley, in 16 years of living in that home and paying rent on time, did you ever receive a single direct communication from anyone at Pierce Industries acknowledging a concern you had raised? Marcus looked at her. Then he looked out at the gallery, not at Caldwell specifically, just out at the room. No, he said. Not once. Grace nodded. Thank you. No further questions. Holt's cross-examination was competent, but couldn't undo what Marcus Holley had already placed in the air of that courtroom. Caldwell watched the old man walk back to his seat and leaned toward Holt to whisper something. Whatever he said made Holt press his lips together and look down at his notepad. The third afternoon was when things shifted. Grace called a Pierce Industries compliance officer named David One, who had left the company 18 months earlier. What one described, under oath, was a system, not a series of mistakes or oversights, but a deliberate internal system in which tenant complaints were logged, categorized by financial priority, and then systematically deprioritized based on how likely the company deemed it that a given tenant could mount a legal challenge. Units in lower income brackets were flagged in the system as low risk. That meant their complaints went to the bottom of the pile. Sometimes they stayed there indefinitely. The courtroom went completely still. Grace let the silence expand for just a moment before she asked, and was this policy documented internally? When said yes. There's an internal memo. I have a copy. Bradford Holt was on his feet before one finished the sentence. Objection, Your Honor. This witness cannot introduce documents that have not been entered into evidence. Judge Mosley looked at Grace. Counsel? Grace was already handing a copy to the bailiff. Your Honor, we move to admit Plaintiff's Exhibit 41, the internal compliance prioritization memo dated March 2019 and bearing the digital signature of Pierce Industries' then Director of Operations. The memo went in. Holt sat back down. Caldwell's jaw tightened. The journalist in the back row was typing so fast you could hear the keys from 3 seats away. That evening, a clip from the courtroom's audio feed, which was permitted under Georgia court rules, circulated on social media. It wasn't the memo itself, which would take time to fully process in the public. It was Marcus Holley's answer. Not once. That was the clip, 12 seconds long. By midnight, it had been viewed 400,000 times. Caldwell Pierce saw it on his phone in the back of his car on the way back to the hotel. He handed the phone to one of his assistants and stared out the window and said nothing. What happened on the fourth morning was the moment the case stopped being just a case. Judge Mosley had called both teams in for a pre-session conference at 8 o'clock. Standard procedure given the prior day's developments. When the formal session began at 9, she took the bench. The bailiff called all rise, and the room stood. Caldwell Pierce again did not. This time it wasn't the relaxed carelessness of the first morning. This time it looked different, deliberate. He sat with both hands flat on the table, looking straight ahead, and the room understood immediately that this was not a mistake. Judge Mosley Saturday, she looked at him for a long moment. the kind of moment that has weight you can feel in your sternum. "Mr. Pierce," she said, "you are in contempt of this court." Bradford Holt rose from his chair. "Your Honor, my client means no disrespect. He's simply—" Judge Mosley raised one hand, and Holt went quiet. She kept her eyes on Caldwell. "Mr. Pierce, I'm speaking to you directly. In this courtroom, every individual, regardless of their net worth, their connections, or their personal opinions about any given proceeding, is required by law to rise when this court is called to order. You have now refused to do so twice. This is not a cultural misunderstanding. This is not a scheduling conflict. This is contempt. Do you understand what I am telling you?" Caldwell finally looked at her. His expression was not hostile. It was something worse. It was dismissive. The look of a man who has decided that the person speaking to him does not have the standing to compel him to do anything. "With respect, Your Honor," he said, his voice smooth and almost gentle, "I think there's been a lot of ceremony in this process that doesn't necessarily translate into—" Judge Mosley cut him off. "Mr. Pierce, I'm going to stop you there. The fact that you just used the phrase 'with respect' while sitting down in a courtroom and speaking to a federal judge about ceremony tells me everything I need to know about where your head is. I'm fining you $5,000 for contempt. If you fail to stand at the next call of court, I will double that fine, and I will consider whether your conduct warrants additional sanction. Am I clear?" Caldwell said nothing for a beat. Then, "Yes, Your Honor." Bradford Holt exhaled quietly and sat back down. Grace Tillman kept her face forward, but the man seated directly behind her, one of the housing advocates who had followed the case for 2 years, quietly pressed his fist to his mouth. The thing was, Caldwell Pierce had made a calculation. It was the wrong one, but it was a calculation nonetheless. He believed that the contempt fine was manageable, that the optics of resistance played better with his shareholders than the optics of submission, and that Judge Mosley would process the payment, note the defiance, and move on because judges, in his experience, were ultimately part of a system that protected people with the resources to navigate it. He had never been in front of Judge Elaine Mosley before. The hearing continued. Grace Tillman methodically laid out her case, piece by piece, with the patience of someone who had been waiting a long time for this room. Holt's counterarguments were polished but increasingly reactive, playing defense against a body of evidence that had been assembled with a care and thoroughness that was hard to unravel in real time. The internal memo was damaging. The testimony from David was damaging. And then there was the financial record Grace introduced in the afternoon session, showing that Pierce Industries had allocated more money in a single fiscal year to renovating 3 luxury penthouse units than it had spent on maintenance across all 37 of the plaintiff's units combined over the same period. Holt objected 3 times during that presentation. He lost all 3. Caldwell spent the afternoon writing notes on a legal pad and passing them to Holt. Holt read them and occasionally shook his head slightly. Whatever Caldwell was suggesting, it wasn't landing. At 4:15, Judge Mosley called an early end to the session. She had scheduling matters to address, she said, and they would resume at 9 the following morning. The bailiff called all rise. Caldwell Pierce stood up. It was a small thing, just a man rising from a chair like every other person in the room. But the gallery noticed, and the journalists noted it, and something about the moment felt like a deflation, like watching a bluff finally get called. Grace Tillman gathered her files and glanced toward Marcus Hawley, who was sitting with his wife in the gallery. He gave her a small nod. She gave one back. Outside the courthouse, a small crowd had gathered. They weren't hostile, just present. People who had followed the case and wanted to be near it. A few of them held signs that red housing is not a luxury. A few more were just standing quietly on the steps with folded arms and a specific expression of people who have been waiting a long time for something to move. When Grace walked out, a few of them recognized her. One woman, older, in a yellow coat, said simply thank you. Grace paused and said, "We're not done yet, but we're close." On the 5th and final day of the hearing, Bradford Holt requested a private session with Judge Mosley before proceedings began. Grace was notified and both sides filed into chambers. What happened in that room took 40 minutes. When they filed back out, Holt's expression had changed. Not dramatically, just enough for someone watching closely to notice that something had shifted in his posture, something that looked like a man who had finally heard a piece of information he couldn't maneuver around. The session opened. The bailiff called, "All rise." Everyone stood, including Caldwell Pierce, though he did it slowly and with the deliberate quality of someone doing something they resent. Judge Mosley took her seat and looked out over the courtroom. She announced that in light of the evidence presented during the hearing and the conclusions of the in-camera discussion, she was prepared to issue a ruling. Both parties have been given the opportunity to review the court's summary findings before this session. The ruling would now be entered into the record. The courtroom did not breathe. Judge Mosley picked up the document in front of her and read steadily, without theater, without pause. The court finds in favor of the plaintiffs on all primary counts. Pierce Industries is found to have engaged in a pattern of deliberate neglect and discriminatory prioritization of tenant complaints consistent with the documentation entered as Plaintiffs' Exhibit 41. The court finds that the plaintiffs suffered material harm as a direct result of these policies. Pierce Industries is ordered to pay restitution to each plaintiff household in amounts detailed in the court's attached schedule, totaling $4.7 million collectively. Additionally, Pierce Industries is ordered to submit to a 2-year audit of its property management practices to be conducted by an independent court-appointed monitor. The company is further required to establish a tenant advocacy office within 60 days and to fund it to a minimum operational level specified in the court's order. She set the document down. The gallery was silent for exactly 3 seconds. Then it wasn't. The sound that came up wasn't applause, exactly. It was more human than that. It was the sound of people who had been holding something in for a very long time, finally being allowed to let it go. Tanya Reeves, seated in the 3rd row, pressed both hands over her face. Marcus Holly reached over and took his wife's hand. A woman near the back said, "Oh my God," softly enough that it was almost a prayer. Grace Tillman sat very still for a moment, her hands folded on the table, her eyes on the bench. Then she closed her notebook and took a slow breath. Caldwell Pierce stared straight ahead. His face was the face of a man who had just understood, for the first time, that something had happened in this room that he could not reverse by writing a check or making a call. The fine he had paid for contempt, the $5,000, had been nothing to him. This was different, not because of the money, though $4.7 million was not nothing even to a billionaire. It was different because of what the court order meant going forward. The audit, the monitor, the mandatory tenant office. Those were not inconveniences. Those were structural changes embedded now in the legal record that would follow Pierce Industries for years. Bradford Holt leaned over and said something quietly. Caldwell said nothing back. Outside, Grace stood on the courthouse steps with the afternoon sun behind her and spoke to reporters for about 10 minutes. She thanked her clients for their courage. She thanked the witnesses who had come forward. She said that the ruling was significant not just for the 37 households represented in the case, but for the thousands of other tenants in Pierce-owned properties who now had a legal framework to point to. She said the work wasn't over. It was just beginning. Someone from the crowd asked her what she thought about Caldwell Pierce refusing to stand for the judge. Grace was quiet for just a moment, that characteristic pause that made people lean in. Then she said, "I think that moment told the room everything it needed to know about who he believes the law is for. And I think the ruling told the room who the law is actually for. That's not my opinion. That's the court's record." Caldwell's publicist released a brief statement that afternoon on behalf of Pierce Industries, expressing disappointment with the ruling and indicating that the company was evaluating its legal options. There was no mention of appeal, which told attorneys who read it that an appeal was being seriously considered but had not yet been decided. What happened next was not in any legal filing. It played out over the following 2 weeks in smaller rooms and quieter conversations. A shareholder meeting was moved up. Two members of the Pierce Industries board of directors made calls to Holt's office seeking clarity on the scope of the audit. A story ran in a major business publication under the headline "The Cost of Contempt," examining the case in detail and noting that the optics of a billionaire refusing to stand for a black judge had generated coverage the verdict itself might not have produced on its own. The article did not editorialize. It didn't have to. Caldwell Pierce gave one interview, brief and carefully managed, in which he described the case as a misunderstanding that had been resolved by the court and said he was committed to the changes the order required. He did not mention Judge Mosley. He did not mention Marcus Hawley. He did not mention Tanya Reeves or the 35 other families whose names were attached to the suit. Judge Elaine Mosley said nothing publicly about the case after the ruling. That was not unusual for her. She had never been someone who narrated herself. She showed up, she did the work, and she left the record to speak. But the people who appeared in her courtroom in the weeks after the Pierce ruling noticed something. The room felt different, not louder or more dramatic, just more settled, like a space that had reminded itself of what it was for. Grace Tillman returned to her office the evening of the ruling and sat for a while without turning on the lights. Her paralegal knocked and asked if she needed anything. Grace said no. Then she said actually yes. Call Marcus Hawley and tell him he can start looking for a new place. Tell him we'll help with whatever he needs. 3 months later, at a housing symposium in Atlanta, Grace was invited to speak on the outcome of the case. She didn't use slides or statistics. She just talked. She described what it had meant to her clients to be heard by a court. She described the way Marcus Hawley had walked to the witness stand with his cane and his dignity and given testimony that couldn't be cross-examined away. She described the moment the verdict came in and the sound gallery made. And then she said something that stopped the room. She said, there was a man in that courtroom who decided before the hearing even started that the judge in front of him didn't warrant his respect. That the law in that specific room on that specific day wasn't something he needed to take seriously. And for a while it must have seemed like he was right because nothing bad had happened to him yet. That's the thing about accountability. It doesn't always show up on your timeline. Sometimes it waits until you're in a room with someone who isn't impressed by what's in your bank account. And then it arrives all at once. The audience was quiet. Then someone started clapping and the rest followed. What Caldwell Pierce thought about any of it, nobody could say for certain. But the Pierce Industries Compliance Department was restructured within 60 days of the ruling. The Tenant Advocacy Office opened on time. The court-appointed monitor filed her first interim report 7 weeks later and noted, in careful legal language, that the company's internal complaint response systems had already improved measurably. Whether that was genuine change or strategic compliance was something only time would show. That was the thing about accountability. It wasn't a single moment. It was the long work of proving over and over again, through choices made when no one was watching and no judge was present, that the lesson had actually landed. Judge Mosley sat in her courtroom on the morning her next case began. The bailiff called "All rise," and everyone in the room stood. She took her seat, adjusted her glasses, and got to work. Some lessons get written into the record. Others get carried home in the chest of everyone who witnessed them. The best ones do both. Power without humility is just arrogance on a timer. And sooner or later, every timer runs out. If this story moved you, share it with someone who needs to hear it. Because accountability isn't just something that happens in courtrooms. It's something we build every day, one choice at a time, one room at a time.